Picture this for a second. You're just casually scrolling through your phone, checking your accounts, and your stomach completely drops. You realize a business you trusted has basically drained your bank account. It's a total scam. In that moment of sheer panic, you probably want the government to step in right that second, freeze absolutely everything, and get your money back, right? But, okay, let's flip that scenario completely. What if you own a perfectly legitimate, hardworking business, and out of nowhere, a government minister just freezes all of your assets, your accounts are locked, and all based on a mere suspicion? Suddenly, that unchecked power looks a lot less like protection and a whole lot more like tyranny. So how do we actually find the middle ground?
Welcome to today's Explainer, where we're going to unpack a truly fascinating legal battle that went all the way to the Constitutional Court of South Africa. It's the case between Janse van Rensburg and the Minister of Trade and Industry. This case forces us to look right at that crazy tension between giving the government enough teeth to actually stop ruthless scammers, while making sure those same teeth don't chew right through our fundamental constitutional rights.
Okay, let's dive into this. Here is our roadmap for the Explainer today. First, the consumer protection dilemma. Second, two drastic government powers. Third, the case of the moot law. Fourth, unchecked ministerial power. And finally, the court's balancing act. Let's get right to it.
Part 1. The consumer protection dilemma. Defining the problem.
To really understand this case, we have to look at the real-world problem that sparked the whole thing: shady commercial schemes taking unfair advantage of the public. To tackle this, the government created the Consumer Affairs Act, which is built entirely around the concept of an unfair business practice. The definition here is super broad. It covers basically any business practice which has the effect of harming relations, unreasonably prejudicing, deceiving, or unfairly affecting any consumer. And listen, the government's initial intention here was genuinely noble, right? They wanted to cast a really wide net to catch those highly sophisticated scammers who might technically be operating just within the letter of the law, but were still causing massive financial harm to the public.
But here lies the core conflict of our explainer. On one side, you have the absolute, undeniable necessity of protecting vulnerable consumers from these really harmful scams. But on the other side, you have the duty of a democratic state to respect the fundamental constitutional rights of its citizens. You literally cannot just hand the government a massive, unguided sledgehammer to solve a problem, no matter how noble the original intention was. There absolutely must be rules.
Moving on to Part 2, two drastic government powers, the tools of the trade.
Now, what's really interesting about this slide is how incredibly aggressive these powers actually were when they were first written. This whole constitutional showdown was sparked by two very specific, sweeping provisions in the Consumer Affairs Act. First up, Section 7.3. This gave investigating officers the power to conduct search and seizures without any judicial authorization. Like none. No warrant required whatsoever. Second, Section 8.5a. This gave the Minister of Trade and Industry the power to stay, which basically means to pause or prevent, any business practice under investigation, and instantly attach or freeze their money and property.
And let me tell you, the stakes for an individual or a business caught up in this were just massive. If the minister issued a notice against you and you failed to comply, you weren't just getting a slap on the wrist. No way. You were looking at a criminal penalty. We're talking up to a 20,000 Rand fine or up to 2 years in prison. Or both. So if you found yourself caught in this web, your life and your entire livelihood could be turned upside down in an instant.
Which brings us to Part 3, the case of the moot law. A problem solved? So the applicants in this case headed straight to the High Court. They were terrified of these sweeping powers, and rightly so. But a funny thing happened regarding that first search and seizure power. By the time the Constitutional Court actually heard the case, they declared the issue moot. Now, if you aren't familiar with the term, mootness is a legal concept that basically means an issue no longer presents an existing or live controversy, so making it completely unnecessary for a court to decide on. Basically, the problem resolved itself, so it'd be a total waste of the court's time to rule on it.
So why was it moot? Well, because Parliament actually realized their mistake and stepped in to amend the law before the Constitutional Court even had to make a decision. They changed Section 7.3 so that any search or seizure now absolutely requires a search warrant issued by a magistrate. Simple as that. Because the law was already fixed, Judge Goldstone noted that the basis on which the applicants approached the court had fallen away, and confirming the lower court's order would, quote, serve no purpose. Just like that, the whole warrantless search and seizure threat was neutralized.
Part 4, unchecked ministerial power, using a sledgehammer on a fly.
Let's move to and see how this builds, because that second power, Section 8.5a, was left completely untouched by Parliament,
And this power was so incredibly vast, it essentially allowed the minister to financially paralyze a business on a whim. Let's actually look at how terrifyingly fast this procedure happens in practice. Step 1, the minister issues a notice. Step 2, assets are frozen and the business is halted immediately. Step 3, absolutely zero prior warning is given to the people affected, literally none. The minister could take this devastating action simply on the recommendation of a committee, based on totally untested allegations. By acting completely without warning, Section 85A completely bypassed a bedrock fundamental principle of law known as audi alteram partem, which translates to listen to the other side. It's basically your fundamental right to be heard before a decision is made that could ruin your life. Now, the minister argued that, look, if they gave scammers notice before freezing their accounts, the scammers would just immediately hide the money, right? The element of surprise was the whole point. And honestly, the court actually agreed that an urgent surprise procedure might sometimes be necessary. But the way this specific law was written, it just went way, way too far.
And this brilliantly illustrates just how much of a sledgehammer this law really was. Just look at the collateral damage here. The law actually stated the minister could attach property held by any person on behalf of a customer, debtor, or creditor of the investigated person. That meant innocent people, people whose names weren't even anywhere on the minister's notice, could literally wake up to find their bank accounts frozen and their own businesses destroyed, all just because they had some vague, tangential link to an investigation. It's wild.
Because the legislature gave the ministers such massive, sweeping power without providing any sufficient guidelines on how to actually use it, the Constitutional Court finally put its foot down. They ruled that Section 85A violated Section 33 of the Constitution, and Section 33 is huge. It guarantees everyone the right to administrative action that is lawful, reasonable, and procedurally fair. Unchecked, completely unfettered power is, by its very nature, unfair.
Which brings us to our final part, Part 5. The court's balancing act, finding the middle ground.
So the court strikes the law down. Boom. Game over, right? Well, actually, scratch that. Not exactly. The court realized that if they just instantly deleted this law from the books, unscrupulous scammers would absolutely take advantage of the loophole to hide their assets and cheat the public while Parliament spent, a year trying to rewrite the rules. The court had to get pretty creative here. They decided to suspend the invalidity of the law for 12 months to give Parliament time to fix it. But to protect citizens from the minister's unchecked power during that gap year, the court looked to the common law concept of an interdict. An interdict is basically a court order used to stop immediate, irreparable harm. The court borrowed the really strict rules used for interdicts to build a temporary safeguard.
So, the crucial point is that this resulted in a brand new 5-part interim checklist. The court ruled that until the law is officially fixed, the minister can only freeze assets without warning if they can objectively satisfy these 5 very strict criteria. Let's run through them. They must have a reasonable suspicion of an unfair practice. They must apprehend irreparable harm to the public. There must be no alternative remedy available. The balance of convenience has to actually favor the public. And, crucially, they must reasonably suspect the person actually intends to conceal their assets.
But the court didn't stop there. To bring some actual fairness and transparency back into the equation, they added one final really important requirement. When the minister finally drops the hammer and issues the freeze notice, they must simultaneously hand over a written statement of facts explaining exactly why they met that 5-part checklist. And they must explicitly advise the target of their right to take the matter to court on appeal or review. So the element of surprise is maintained to catch the scammers, for sure, but the target instantly knows exactly what they are accused of and exactly how to fight back in court.
This ruling represents a masterful balancing act by the Constitutional Court. They fully recognize the very real danger of unfair business practices, but they totally refuse to sacrifice administrative justice to fight them. It leaves us with a pretty compelling final thought. Look at that 5-part checklist the court created. Does this strike the perfect balance for you? Does it give the government enough agility to catch modern, fast-moving scammers while still ensuring innocent citizens aren't just crushed by the machinery of the state? It's a really delicate tightrope, and one that defines the very health of a democracy. Thanks so much for joining me in this explainer today, and keep questioning the balance of power around you.